Good afternoon, everyone. My name is Robert Hersey. Happy Monday to each of you. And on behalf of the Florida Alcohol and Drug Abuse Association, welcome to today's webinar titled 2024 Legislative Updates to the Baker and Marchman Acts. This webinar is being made available through a collaboration of the Florida Department of Children and Families and the Florida Alcohol and Drug Abuse Association. Please note that as an attendee, you are in listen-only mode and are only able to view your name. Your webcam and microphone have been disabled. If you have questions, please send them to all panelists by using the chat panel. The button to open the panel is usually located on the upper right side of your monitor. Please use the chat panel to send any questions you may have as you think of them. The presenter will be answering questions throughout today's presentation. Our audio is broadcast through the internet to your computer. If you experience poor computer audio at any time during today's presentation, there are a few options to try using the Communicate menu. For computer audio, click the Communicate menu, then click the Audio Connection panel. Click Disconnect. Click the Communicate menu and Audio Connection panel again, then click Call in using the computer and follow the instructions. If you continue to experience poor audio through your computer, try using the I will call in option under the Communicate menu. The access code and event password will be posted in the chat panel momentarily. You must be connected to the audio of this presentation and view it on screen to receive a statement of completion. We are unable to verify attendance if you are not connected to WebEx via a computer or mobile device. Therefore, call-in only attendees will not be eligible for a statement of completion or CEUs. The recording and materials used in today's presentation will be available on the FATA website within 30 business days. To access the recording and PowerPoint, visit www.fata.org, navigate to the Resource Center, and click on Training Library as shown on the screen. FATA produces many webinars and workshops through the support of the Florida Department of Children and Families. To help participants track credits earned through attendance, we host an online community that provides a personalized digital journal where participants can maintain statements of credit for webinars and workshops taken through the Florida Alcohol and Drug Abuse Association. A statement of completion and CEUs for up to 2 continuing education credits are available for participating in today's webinar. CEUs are available for persons licensed through the Board of Nursing, the Board of Clinical Social Work, Marriage and Family Therapy, Mental Health Counseling, and for persons credentialed through the Florida Certification Board. Completing the post-webinar evaluation is necessary to receive a statement of completion or CEUs. Please note that the evaluation will close at the end of the day on Thursday, October 3rd, 2024. At the end of today's webinar, you will have 3 opportunities to complete the post-webinar evaluation. A link I post in the chat, a follow-up email from WebEx, and an automatic web browser pop-up when I end the webinar. To complete the evaluation, you will first need to register or sign into your account. Please ensure your name and email address match the name and email you use to register with WebEx. Information you provide FATA as part of registering remains confidential. If you are a licensed healthcare practitioner, be sure to include your Florida license number for reporting to CE Broker when you register with our site for the first time. If you are certified with the Florida Certification Board or licensed outside the state of Florida, you do not need to provide your certification number when you register with our site. If you need assistance with account registration, login information, or accessing the evaluation, fill out a contact form on our website or email training@floridabha.org before October 3rd, 2024. Please note that WebEx monitors the arrival and departure times of attendees and provides a report upon completion of the event. We are not permitted to provide a statement of completion if you do not attend the entire webinar, and we are not permitted to provide partial CE credit. Statements of credit will be posted within 30 business days after the evaluation closes in the professional development section of your FATA account. For licensed practitioners, CEUs will be reported to CE Broker within the same time frame. This presentation is intended solely for educational purposes. The views, opinions, information, and content expressed in the presentation are those of the presenter and do not necessarily reflect the views, opinions, or policies of the state of Florida, the Florida Department of Children and Families, the Florida Alcohol and Drug Abuse Association, or the Florida Behavioral Health Association. Attendees should note that sessions are recorded and published in various media. Our presenter today is Melissa Larkin-Skinner. Melissa is a licensed mental health counselor with 3 decades of experience working in the behavioral healthcare field, where she started as a volunteer and has practiced in a variety of clinical and leadership roles. Melissa has extensive experience with Florida's crisis system of care. Over the past 25 years, she has initiated involuntary exams, conducted involuntary and voluntary evaluations, participated in Baker Act hearings, and reviewed and signed petitions. She has also served as an administrator for a crisis stabilization unit in an inpatient psychiatric hospital, opened one of Florida's first central receiving facilities, and participated in multiple Baker and Marchman Act review/revision task forces and committees. Melissa recently decided to tackle the challenge of safe, affordable, and supported housing as president of Community Assisted and Supported Living. Prior to her new role, Melissa served as CEO of Centerstone in Florida. She earned a master's degree in rehabilitation counseling from the University of South Florida and an MBA from St. Leo University. And now I will turn it over to our presenter, Melissa. Melissa, the floor is yours.
All right, good afternoon, everyone. I would be remiss if I didn't thank you for being here this afternoon. Florida has had a rough couple of days, as have many other states. And I just wanted to say, I sincerely hope you and your loved ones are safe and have had minimal impact, because I know some of my friends and colleagues have had tremendous impact because of Helene. So I'm grateful. I'm grateful that you're here. I'm grateful to be able to do this presentation. It was iffy for a little while. I want to say ahead of time, this is a highly technical presentation. So what you're going to find is 59 slides of a lot of words. That's not typically my style, but I want to make sure, and the DCF and FBHA and FAD, I want to make sure that you have all of the relevant information regarding these changes. So I will say one thing, please, and I know Robert said this, but please go ahead and put your questions in chat as they arise. I want to at least make this a little bit interactive, and I want to be able to, I want to be sure to have an opportunity to answer your questions if I can. That said, if I cannot answer a question, we will record your questions and find the answers, and then we will provide them to everyone sometime afterward. Obviously, it won't be this afternoon, but we'll try to get them up to you within the next week or two. One other thing that's a little bit of housekeeping, and that is that at about 3 o'clock, we're going to have a 10-minute break so that each of us just has 10 minutes to recenter ourselves, hopefully recenter our attention span, and take care of anything that we might need to take care of that we can do in 10 minutes. All right. So just a disclaimer real quick. The information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials presented are for informational purposes only. Having been a person who's been intimately involved in all things Baker and Marchman Act for the last 20 plus years, my recommendation is if at some point you do believe you need legal advice, to make sure you go to the leadership at your organization and perhaps tap the whatever attorney your organization might use when it comes to understanding the laws that are, let's say, put into place once these acts are passed into law. And by the way, they are already passed into law, but I just wanted to make sure we understand the process. So what we're going to discuss today is changes to the acts, both the Baker and the Marchman Act, how that may impact your practice, and then how we've been trying to align the two acts. House Bill 7021, mental health and substance abuse. So this past legislative session, that's 2024, the legislature passed House Bill 7021, which modified the Baker and Marchman Acts. And that legislation went into effect July 1st, 2024. The goals of the legislation were multifold, let's say. One was to increase access to services, which is something that we always are trying to do as demand increases. Two is to align judicial processes for more consistency. Over the years, there have been a bit of differences between the Baker and Marchman Acts, which sometimes causes confusion for everyone. Number three is to improve discharge planning after a crisis. The obvious goal here is that we want to prevent folks from being readmitted to receiving facilities. And then number four was to increase involuntary service capacity. In addition to the House bill, Senate Bill 7016, healthcare, was passed. And that one, it had a goal of, overall goal, let's say, of enhancing healthcare across the state. That legislation went into effect when it was signed, which was March 21st, 2024. And in terms of behavioral health, the purpose behind the bill was to address workforce challenges, which we've all had, and in particular in the areas where we have shortages of professionals, and to increase the scope of mobile response teams. And I'll just add here that mobile response teams have proven to be incredibly effective at addressing people's needs outside of inpatient hospitalization or CSUs. And therefore, it is something that the legislature as well as state agencies are interested in increasing the scope of, so that that success can take on an even broader impact or make an even broader impact. So we'll start with legislative changes to the Baker Act. The Baker Act is also known as the Florida Mental Health Act. It is Chapter 394, Part 1 of Florida statutes. It was passed into law in 1971 with the following purposes. One, to protect the rights of persons examined and treated for mental illnesses. Two, to provide for stabilization of an immediate crisis and maintain the safety of the individual and the public. Three, to encourage voluntary treatment. And then also to provide procedures for, one, involuntary and voluntary examinations and treatment in designated receiving facilities and state mental health treatment facilities. Two, court processes and court orders. And three, required notifications, which are all very important to address. So the first major change, although it has little impact on the receiving facilities themselves, is regarding law enforcement. And it's a simple change from using the word shall, which implies must, to may. So it changed the statute to state that law enforcement officers may initiate an involuntary examination rather than they shall initiate an involuntary examination for individuals who appear to meet the criteria. And so that overall gives law enforcement officers more discretion when making a decision about how to proceed. Also, when transporting a minor, if the parent or legal guardian is present, the law enforcement officer must give the parent or legal guardian the name, address, and contact information for the facility they are taking the minor to before departing. The one caveat to that is that law enforcement has the discretion to consider any safety and welfare concerns for the minor. And a good example of that is if there is suspicion or knowledge of the minor having been abused or neglected, then the law enforcement officer has some discretion in order to protect the minor. With regard to workforce, specifically psychiatric nurses, and I'm particularly happy with this change. 1, the years of required clinical experience under the supervision of a physician is reduced from 2 years to 1 year. 2, psychiatric nurses are allowed to perform additional duties in designated receiving facilities within established protocols with a psychiatrist. Now, the important part of this is that prior to this law, or the changes of this act, that this act imposes upon the law, is only psychiatrists could perform these functions. So the first is a psychiatric nurse can determine competency to give express and informed consent. 2, order admissions to the unit. 3, order emergency treatment. So emergency treatment orders now can be entered or verbally ordered by psychiatric nurses. 4, psychiatric nurses can speak with guardian advocates prior to the guardian advocate being able to give consent. 5, psychiatric nurses can order observation and medication on a children's CSU. 6, psychiatric nurses can provide second opinions for involuntary, inpatient, and outpatient services. 7, psychiatric nurses can restrict a person's right to access their medical record if the psychiatric nurse determines that access to the medical record is harmful to that person. Workforce changes with regard to psychologists. The requirement for a clinical psychologist to have 3 years of postdoctoral experience is removed from the definition. However, there are still a number of things that will require, or activities that will require the psychologist to have 3 years of postdoctoral experience. 1 is to receive a request for discharge of a voluntary patient. 2 is approve a discharge. 3 is provide a second opinion for involuntary inpatient or outpatient services, unless the petitioner certifies allowable professionals are not available. 4, determine noncompliance with involuntary outpatient services.
Melissa, there is a question in the chat. An individual asked, a Florida MCAP and CMHP cannot Baker Act, but a law enforcement officer can.
That's correct. And it's always been that way. So I'll just try to explain it. So it's always been that law enforcement has been able to initiate an involuntary Baker Act. There are a lot of reasons for that. 1 is they are the most likely people to, have contact with many of the folks that we need to serve, many of the folks who are really struggling. And 2 is the assumption is not that law enforcement are experts on mental health or addiction, because they're not, and they will readily admit that. And I would argue often, based on my conversations with many law enforcement over the years, that they don't really want to be able to do it. But Florida recognized early on that because they have the most immediate access to folks, they need to have the ability to do something other than take everyone to jail. And so that it really kind of explains the reason behind the Baker Act. And if I remember correctly, the information, or rather the description in the Baker Act, is that law enforcement suspects that whatever behavior is occurring, whatever danger is occurring, is due to the person having a mental health issue. All right, the Act also addresses patient rights. So individuals served in designated treatment facilities or state mental health treatment facilities, either voluntarily or involuntarily, continue to have the right to communicate with outside persons and receive visitors, but that right may be restricted. And my experience over the years is there are a number of reasons why that might be restricted. Many times it's because the patient is calling some person over and over and over, and that person says, please don't let them call me anymore. Another reason may be that the person is calling law enforcement repeatedly or calling, who knows, the governor's office, for instance. We've had that before. And, we have to intervene until they are have less symptoms, let's say. So one way to intervene is to say, okay, and this has to be whoever the provider is, so that's the psychiatrist or now the psychiatric nurse practitioner or advanced registered nurse practitioner, rather. They can say, we are restricting communication, mail or visitors. They have to tell the person immediately, and then they also have to immediately tell the person's attorney, their guardian advocate, or representative. And so we all knew there would be some questions about what does immediately mean, and the Department of Children and Families has given us that definition, and they interpret immediately as within 3 hours. So if you have a provider that is going to restrict, I'm so sorry. Is going to restrict communication for any reason, it has to be documented. It would also need to be in an order, because like everything else in an inpatient unit, it needs to be in order by the provider. And then the staff at the facility will need to let whoever in that whole array, that whole list of people, the attorney, the guardian advocate, or the representative, and certainly the patient, they need to let them know within 3 hours of putting that order in place.
Melissa, I have a couple of questions in the chat. The first is, does psychiatric nurse refer to APRNs only?
It does.
Okay. And then I have another question that says, are people who are master's level licensed school psychologists able to perform a Baker Act?
Yes. Sorry, I had to think through that question. Yes, as long as they're licensed in the state of Florida, they can initiate a Baker Act.
And then finally, most recently, what does documentation look like for notification of restriction of communication and mail visitors? Tanisha, I don't know if you can clarify that question, but in regards to documentation, Melissa, what does that look like?
So the first thing has to be the order. So the provider has to enter an order, just like an order for medication. It has to be an order. And then as far as the documentation for informing the other parties, I think that's probably up to your facility, whether that can be verbal or you need to have a piece of paper you send them, or that's a process that I think each facility will have to figure out. But you will have to show some sort of documentation that one of those parties involved, or all of them, if they have all of them, were in fact communicated with about the restriction.
Got it. We have a few more questions in the chat. One person has asked, they are a LMHC and also a certified school counselor. They've been told that they cannot Baker Act in the school setting. Can you confirm if that has changed? And they clarify that they cannot Baker Act because they are employed as a certified school counselor. They're not employed as an LMHC.
So if you are a licensed mental health counselor in the state of Florida, you can initiate a Baker Act in any setting. That is not Florida law. If you've been told that, that would be a school district policy or a principal's policy. But I would, and this is my opinion, there was a whole thing at the beginning about the opinions being mine as an LMHC. I would say that if you recognize a person is struggling with a mental health issue and they need assistance and perhaps an evaluation for admission, then I would initiate the Baker Act. But you have to make up I mean, you have to make that decision yourself based on what your employer is telling you. Obviously, you wouldn't want to lose your job, but I also think it's worth having a conversation perhaps with whoever made that rule from your employer.
And then the last question for now is, can a non-psychiatric nurse practitioner initiate a Baker Act? And what about physician's assistants? It says House Bill 573 added provisions that support this statement, but it's still vague.
You know, I don't want to speak erroneously. I think I know the answer, but I'm going to get clarification on that one. So if we can just write that down. I know that in the past, a physician's assistant could not, but then there was some discussion about it because they are an extension of the psychiatrist, that perhaps they could. But like I said, I don't want to speak erroneously and give people the wrong information. So the good news is there's a person listening who's feeding me information, and here's all the questions. So a physician's assistant can, in fact, initiate an involuntary Baker Act. And it is what I thought, and that's they are an extension of the physician, and physicians can initiate involuntary Baker Acts. As far as advanced registered nurse practitioners who don't have the 1 year, I believe they can, but I do definitely will get clarification on that as well. And maybe my lifeline that's on here will tell me. Okay, there we go. See, I already have the answer. APRNs can, in fact, initiate an involuntary Baker Act. They do not have to have the 1 year of psychiatric training. So there you go. PAs, APRNs, physicians, any type of physician, not just a psychiatrist, law enforcement, LMHCs, LMFTs, and LCSWs, and clinical psychologists. Was that all of the?
I believe so for now, and I have asked the individual that asked that one question about non-psychiatric nurse practitioners to shoot their email over to me so we can follow up with them.
Okay. I think I did. Yes, I did. Patient rights. All right. Involuntary examination. The Baker Act. Let's see. The criteria, sorry about that. The involuntary examination criteria was amended slightly, and I think that this will make providers happy. So it was amended to state that family members or friends who may help an individual avoid harm must be able and responsible in addition to willing. So the old language was they just had to be willing, but I'm sure if any of you have practiced for a couple of years, you run into folks who are willing but do not have the capacity for one reason or another to actually help that individual avoid harm. And so the legislature added this line, or rather a couple of words, so it's a phrase, able and responsible. The next part is, if a receiving facility does not admit a person that has been arrested for a felony who requires an involuntary examination, the receiving facility may complete the required examination and treatment for that individual via telehealth. Now, this one may be one that kind of confuses folks, but the fact is that a receiving facility is required to examine anyone who is on an involuntary examination, or where an involuntary examination has been initiated. So, but in this case, if they've been charged with a felony, if they've been arrested rather for a felony, then that person can be taken to the local jail, and the receiving facility, instead of having to go out there in person, can provide the required examination and treatment for that individual via telehealth. Let's see, the third one explicitly allows emergency treatment orders to be initiated via verbal orders. So in the past, they had to be written, but now the provider can call in to the facility. So the provider's not on campus, but can call in and give the emergency treatment order verbally. They don't have to enter it themselves. And the fourth one clarifies that the 72-hour examination period begins when the individual arrives at a receiving facility. And there was a question from one attendee before the webinar started and about this specific one. And I know, and it certainly was my practice in prior years, that we considered the examination period to start when the Baker Act was written. So it was the time on the Baker Act. But this clarifies in law that that 72-hour examination period actually begins once the person arrives at the receiving facility, not the time that's written on the Baker Act, unless it's the same time, of course. I do see a question that just popped up about no longer a pause in the hospital for an emergency medical condition. Yes, there's always a pause. So for instance, if you were to admit someone once they get to your facility and you had to send them out, let's say within 12 hours, there would be a pause while that person goes to the hospital. I know there are a bunch of questions, Robert, so do we want to go through those real quick?
Yes, sorry, I was making note of some of them. So there is a question, can we have the regulation that supports APRN regardless of their specialty being able to write a Baker Act? And that person followed up with, can we distinguish between the APRN specialty? PMHNP is a different credential than FNP, etc.
Let's see. So we will work to provide that regulation. And I mean, it should be in 394, but we can look for that.
Somebody asked, do non-psychiatric nurse practitioners not have to have autonomous practice anymore to write a Baker Act?
I'm not sure how to answer that because I wasn't aware that they had to have autonomous practice. I mean, if the law gives someone with a particular type of license permission to do something, then I don't know why they wouldn't be able to do that in any setting unless the employer or provider that they work for says you can't do that. But the law itself allows it.
Got it. And if your question needs clarification, please drop your email in the chat so we can be sure to follow up with you after the webinar. There's a question, can you clarify what is the receiving facility versus a treatment facility? If the receiving facility calls 911 for a medical condition and the patient is transported by EMS to a local hospital for medical clearance, is the 72-hour clock still running, or is there a start stop while the person is undergoing medical clearance?
So a receiving facility, that's actually a specific designation given by the state. There's requirements you have to meet, you have to apply. So your facility would be a designated Baker Act receiving facility, or a designated Marchman Act receiving facility. And then if you're within that 72 hours that you have to do the evaluation or examination, then yes, if the person, your patient, has a medical issue and they go to a medical facility, you would stop the time clock for the period that they're gone until they're medically cleared and returned. If it's after the 72 hours, it's moot. So it's within that 72 hours. So from when they arrive at the receiving facility and then 72 hours in. I hope that answers the question.
For ETOs, do the verbal orders still require the written order signed by the MD?
I will get clarification on that, but my recollection is even when verbal orders are given, they have to be acknowledged or signed off on by the provider that ordered them.
Is the 72-hour law, does that, um, is there a pause of that if the patient went to jail?
I don't know the answer to that. I haven't, I mean, typically, I mean, I need more clarification, I guess, on the question. Are we talking about someone who went to jail, maybe was at the jail for 12 hours and then they brought them to the receiving facility? If that's the case, I would apply the clock doesn't start until they arrive at the receiving facility. Now, if they go to jail from the receiving facility, my opinion would be that you would discharge them because they're in jail.
Got it. Can you reference where in the bill it states there is a pause in the 72 hours for medical clearance?
We'll have to get that. I'm not looking at the bill, so I'm not sure. I can't say exactly where it is. I can only say it's always been there.
Gotcha. And I think the last question for now is going to be the Baker Act currently states that the time noted must be within the preceding 48 hours. Is the Baker Act still valid after those 48 hours?
So that has to do with, let's back up for a second. That's 48 hours prior to a Baker Act being initiated. So let's say I'm a therapist and today's Monday and I have a client and I have a session with the client and I'm a little concerned about the client, but not enough to initiate a Baker Act. And maybe we come up with a plan for the person if they feel worse. And so then let's fast forward to Tuesday and say that person calls in and says they're struggling and the front desk sends them, to my phone and I talk to them and I become more concerned based on my evaluation yesterday. But we still come up with a plan and the person maybe doesn't meet involuntary Baker Act criteria yet because they say they'll call mobile crisis or the hotline if their symptoms get worse, let's say. And then 5 hours later, someone else, let's say one of our other providers or a case manager has contact with that person and is increasingly alarmed about them, then because I saw them personally within 48 hours of that time frame, then I could initiate a Baker Act. That means they don't have to be right in front of me at the time, as long as I saw them at some point in the last 48 hours, rather, the prior 48 hours. So if I saw them at noon on Monday, I could initiate an involuntary Baker Act based on that evaluation any time between noon on Monday and noon on Wednesday. That's what that 48 hours references. Was there anything else or was that the last one?
I believe that is the last one for now.
Okay.
There is one more that just came in. Does the 72-hour evaluation period begin if a Baker Act is initiated in the hospital or only once the hospital gets a receiving facility to accept that patient? I believe this person's asked if they are in the emergency room for just a medical emergency in general, and then it's determined that a Baker Act needs to be initiated. When does that 72-hour window start?
The law now states that the 72 hours starts when the person arrives at the receiving facility. So it doesn't matter how long they were at the hospital or with law enforcement. Doesn't matter when they decided to do it or the time on the Baker Act form itself. What matters is when they actually arrive at the receiving facility.
And that's regardless to what the law reads in section H. That was the follow-up question from that individual.
I would have, like I said, I don't have the law actually in front of me at the moment. It's entirely possible that they haven't made, like, all this criteria, these changes may not have made it into the law yet. Or someone might be working off an old version.
Next question, can there be legislation for the 40-hour CIT training be mandatory for law enforcement officers? So they said,
Well,
for
I mean,
example,
the answer to that is there could be, but there isn't. Although Florida has worked a lot on the issue of CIT training, and it was several years ago, actually, it might have been part of the laws that were changed after Parkland that put more effort into CIT and the development of CIT for all of law enforcement agencies. But could it be? Probably. But is it? No.
and then next question, what if the individual is taken directly to the ER by EMS before being admitted to the receiving facility? What about situations where the ER/hospital cannot find a receiving facility to take them? Can the individual stay at the hospital indefinitely if no receiving facility can be found?
That is up to the hospital. It's up to their criteria and processes and policies. What they do. I mean, they do it now. They end up keeping people, but my experience has been that if they do have people there and they're there, let's say they initiate the Baker Act and then it's done within, they're there 3 days later, 4 days later, often they just release them, has been my experience.
I believe that's it for now.
Okay. All right, involuntary examination. Oh, nope, I already did this one. Let's see. Oh, no, I didn't. I did patient rights, correct? And I did able and responsible. I did telehealth. I did do this one. Okay. So continuing on with involuntary examination, it requires us as facilities, receiving facilities, to do a few things. One is that have the individual's treatment history at the facility. That must be considered when completing the examination. And then also information regarding the individual's conditions and behaviors from other knowledgeable adults. So if there are, in fact, I don't know, let's say a treatment provider, a case manager, a peer, a sponsor, family member, anybody that knows something about this person's condition or behaviors, we are required to get that information from them. Number 6, it adds examples of what constitutes criteria for neglect or refusal to care for self. One of those is repeated admissions despite appropriate discharge plans, which means you're going to have to go back and look at prior discharge plans. And 3 or more admissions into the facility within the immediately preceding 12 months. And I think some folks on the training will probably recognize that as what we call our high needs, high utilizers in many cases. So we need to go back and look at their discharge plans. And if they had good discharge plans, we can consider that as criteria for neglect or refusal to care for self if they didn't follow those. And then also consideration of whether the individual would be able to meet their basic needs without the assistance of staff in the facility. If basic needs cannot be met outside the facility, the individual continues to meet criteria. So why this is important is, at least in my experience, sometimes people were released because the public defender argued that the person was taken care of and their basic needs were being met, while we knew for a fact that the basic needs were being met only because they were in our facility receiving care. And so now that can be actually used as one of the criteria when we do the examination. All right, as far as involuntary services, HB 7021 combines the processes for involuntary inpatient placement and involuntary outpatient services. So if any of you have ever looked at the law and used, for instance, the involuntary outpatient services portion, you'll know that it was a completely separate process and information. So now that has been combined, and as a result, most of the involuntary outpatient services section is stricken and incorporated into the involuntary inpatient placement section. So what remains is that involuntary outpatient placement means the same thing as involuntary outpatient services and definitions. I personally think that is helpful for many reasons, because it was quite difficult often to get the outpatient order or order for outpatient treatment in place, and it required many things, and that's why basically there were barriers and it was difficult and it's not used much statewide. So I think that it is something that providers as well as family members and loved ones will be happy with as far as a change. So the involuntary outpatient services criteria had some removals for this refinement. And this is kind of what I consider this. We've had a number of refinements over the years. This is just the latest refinement of the law. So individuals no longer have to be at least 18 years of age. Individuals no longer require a history of involuntary inpatient placement or incarceration. And individuals no longer require a history of completed or attempted violent behavior towards self or others. So those criteria are actually removed. For involuntary inpatient placement, sorry about that, it's a lot of I's. Certain criteria are amended as follows, and this kind of follows some of the other things that we've already talked about that are changes. One is he or she is incapable of surviving alone or with the help of willing, able, and responsible family or friends. The important thing there is able and responsible. As I said earlier, sometimes people are willing, but they don't meet the level of being able or responsible. 2, without treatment, there is a substantial likelihood that the person will inflict bodily harm on self or others, as evidenced by recent behavior causing, attempting to cause, or threatening to cause such harm. Which references one that I already talked about it's very similar to the basic needs. Obviously, basic needs are being met when someone's in a facility, but they're not going to be met necessarily when they get out. Number 3, all available less restrictive treatment alternatives that would offer an opportunity for improvement of the person's condition have been deemed to be inappropriate or unavailable. Unavailable is really important here because, as we know, services aren't always available. Whatever it is that's less restrictive that the person needs, let's just use FACT as an example, it's not necessarily available. It's either not available in that particular county, or it's not available because the FACT team is full and has a wait list.
Melissa, there are a couple of questions. Is there a time limit between when a Baker Act is written to the time the patient arrives at the receiving facility?
I don't know that the law specifically states a time limit. I know that once they're at the receiving facility, a decision has to be made within 12 hours. But the thing is that receiving facilities, I mean, you have no control, right, over when people come to you. So whatever law enforcement or EMS or whoever's out there, whatever they're doing, you don't have any control over that. What you have to worry about is once they arrive at your facility, then what? And the 72 hours, according to the changes in the law, starts once they arrive, not before.
Got it. Is a release of information required for the outpatient treatment provider to share information on the client's condition to the crisis stabilization unit?
So this is one of those legal opinion ones, but I've heard a lot of things over the years, and what I will tell you is no, because it's healthcare. Now, obviously, you wouldn't necessarily provide contents of progress notes because they have a much higher level of protection. But to give the diagnosis and medication, I would argue that it would be inappropriate not to give that, because then the receiving facility is operating on who knows what information instead of accurate information. And the more accurate the information, the better able they are to provide treatment.
Got it. And then final question for now. If an individual is showing signs of self-neglect, does this meet criteria for a Baker Act?
And what the person wrote after that is correct. If it is due to a mental disorder of some sort or a suspected mental disorder of some sort, then yes, they meet criteria for the Baker Act. It's just one element, and the Baker Act requires both. All right, let's see. So, petitions for involuntary services. The petitions must include the type of involuntary services being recommended, which can be, and this is what I think is exciting, inpatient, outpatient, or both. Must include the length of time recommended for each type of service, the reason for the recommendation, and for involuntary outpatient services, it must include the name of the service provider that has agreed to provide the services. And for involuntary outpatient services, a service plan must be completed in consultation with the patient and or their guardian. So the big thing that you need to know here is the outpatient service provider has to agree to provide the services, and then a service plan has to be developed. That has to be included in the petition. This one also, I think, is great. Electronic signatures on petitions and other documents sent to the clerk of courts are acceptable. That will be very helpful. So filing petitions for involuntary services. 1, service providers treating an individual in the community may now file a petition for involuntary outpatient services. Sometimes my brain gets ahead of my mouth. So what that means in the past, until this law took effect July 1st, to file a petition for outpatient services, the person had to be in a receiving facility, had to be inpatient. That requirement has been removed, and now those petitions can actually be filed from outpatient. For involuntary outpatient services, the petition to continue outpatient treatment may be filed anytime before the expiration of the treatment order. And that's helpful. It used to be that it had to be filed 10 days prior to the expiration. Now you can file anytime up to. I mean, I would recommend filing it as early as possible for a lot of reasons, but that requirement was removed. On inpatient units, if the 72-hour examination ends on a weekend or holiday, the petition for inpatient placement must be filed by ordinary close of business on the next working day, which typically will mean Monday, unless Monday's a holiday, then it'll be Tuesday. Petitions for involuntary services that are filed late will be dismissed. That's important. I think that magistrates have used some discretion in the past. But now the law actually says if you file it late, it will be dismissed. There's no discretion left there at all.
Melissa, how long is a Baker Act good for? Is it until it gets executed, or is there another time limit?
I don't understand that question. So the best I can do is start from the beginning. When a Baker Act is initiated, what it's directing is that the person will be held against their will in a receiving facility until an examination is completed. And that examination has to be done within 72 hours of the person arriving at the receiving facility. So I'm not sure how else to answer that question.
I'll see if they follow up. The second question is, how are outpatient involuntary services enforced? What if a client is not agreeable to attend? What if they do not have transportation?
You know, that is the magic question of the day. I would argue that if a person does not have transportation, then it's not the appropriate treatment if some outpatient service that we're trying to order them to requires them to have transportation. So the idea is that whatever outpatient treatment is being ordered, they actually have the capacity to participate. If they're not agreeable, then let's see, if I go back one or two, one of the things here is E. So 1E tells you for involuntary outpatient services, a service plan completed in consultation with the patient and or their guardian. If the person or their guardian doesn't participate in the development of that service plan, then by default, you're not meeting the requirements of the petitions.
Got it. There is a follow-up question from the individual who asked how long a Baker Act is good for. They said, we received Baker Acts that were written months ago. Is that Baker Act still valid?
No, the way I would look at that is that it expired within the 72 hours. If it's only good for 72 hours and the person is never taken to a receiving facility, that doesn't make the petition indefinite. What the law did and why it changed to once the person arrives at the receiving facility was because they fully acknowledge there are people who sit in hospitals or wherever they are and don't get to the receiving facility and until their Baker Act is almost expired. So they didn't want the burden to be on a receiving facility. So as long as it's still within that original 72 hours from the time that the Baker Act is initiated, then you take them. If it's beyond that, then no, it's not valid. It expired already. Okay. Let's see. Where was I? All right. So pending petitions for involuntary services. And this first one isn't necessarily a change, but it clarifies it. If after filing of an involuntary services petition, the patient is stabilized and no longer meets criteria for involuntary examination, they must be released. If involuntary inpatient placement was recommended, the petition must be withdrawn. So let's say the 72 hours ended on Thursday. So the facility initiated a petition for treatment and the hearing isn't until Wednesday, but the following Wednesday, but by Monday, the person no longer meets criteria, then that person should be released. The petition should be withdrawn. However, for outpatient services, it's a little bit different. So if you are filing a petition for involuntary outpatient services, and because that's what was recommended, then the hearing will still commence. So we referenced a couple of slides ago that a service plan is required to be developed with the patient and or guardian. The service plan must be deemed clinically appropriate by a licensed clinician who works for the service provider that has agreed to provide the services. And the recommended service plan must minimally include diagnosis, including any co-occurring substance use disorder, recommended level of care, medications, and discharge criteria. So there has to be a second opinion for involuntary services. For inpatient settings, the examination by the second provider must be completed within the preceding 72 hours. And 2, for outpatient settings, the examination by the second provider must be completed within the preceding 30 days. And let's see, these changes are referencing the court proceedings. The clerk of courts must provide filed petitions and service plans to the respective managing entity. A managing entity is a nonprofit organization under contract with the Department of Children and Families to manage a network of behavioral health care providers for a specific region of the state. Managing entities do not provide direct services. They create provider networks for DCF 6 regions. Continuances may be granted for 7 calendar days initially. Previously, that was 4 weeks. With additional requests and showing of good cause and due diligence, that continuance may be granted for up to 21 days. So you'll notice it's not necessarily a reduction because 7 and 21 is essentially equal to 4 weeks. It just breaks it up so that the initial is up to 7 calendar days. Medical records must be made available to the state attorney, and the state attorney's office may not use the medical records for criminal investigation or prosecution purposes. I know from experience that this is incredibly important. The state attorneys have always complained that they are basically operating blind. So now they'll be able to have access and be able to hopefully make a stronger case. The state attorney may request a continuance of up to 7 days. Petition individuals may waive their right to be present at the hearing. Hearings on involuntary outpatient services are held in the county where the petition is filed. Hearings on involuntary inpatient placement are held in the county where the patient is located. The state attorney and witnesses may attend hearings remotely, but they must provide all relevant documents by close of business the day before the hearing. Court must allow testimony from knowing adults regarding the patient's history and their current condition. I think it's really important to note here that number 9 says must allow. So it is not at their discretion. They must allow it. The state can introduce transfer evaluations for state hospital recommendations at any time when presenting evidence, but the court cannot consider content unless the person who completed the transfer evaluation testifies. I do see there's a question about can public defenders also access the records, and the answer is yes, they've always been able to access the records.
Melissa, do you need the original copy of the Baker Act for the receiving facility, or will a copy suffice?
I know that you see, this is why I haven't worked in a receiving facility myself for a little while, and I know it used to be you had to have the original, but I believe a copy suffices. I'll make sure that my Lifeline texts me, and we'll get clarification on that question. Let's see. So court orders. If the court deems that involuntary criteria are met, the court may order the patient for involuntary inpatient placement, involuntary outpatient services, or a combination of both based on recommendations in the petition. That to me is kind of exciting because you could essentially, if a person is already inpatient and let's say they need a few more days or maybe a week, you could actually file the petition for them to stay an additional week inpatient. Plus, if you have the agreement of an outpatient provider and a service plan, you could then, once they're discharged, have the order in place already for them to have involuntary outpatient services. So I personally think that's a great change. The duration of the court order for outpatient, inpatient, or both is for up to 6 months. So that's the maximum they can give. They don't always give that. Sometimes they give 3 months, 1 month, 4 months, but the maximum is 6. So discharge planning, high utilizers of crisis services must be referred to care coordination. High utilization is defined as the following: 3 or more acute care admissions or evaluations within 180 days, or acute care admissions that last 16 days or longer. Acute care programs include designated receiving facilities, statewide inpatient psychiatric programs, and inpatient detoxification programs. If care coordination is not available, because we recognize that it's not necessarily available in every county, the receiving facility should contact the managing entity, Medicaid HMO, private insurance provider, or DCF for assistance. A personalized crisis prevention plan must be included in discharge paperwork. So I just realized it's 3:06 and I promised a break. However, I'm going to shorten that break to 5 minutes because we aren't through enough of this. I think we're only through about half of it, maybe. Not quite half. So, and I want to make sure you all have time and we have time to get through it. So, Eric, can we go ahead and start the 5-minute break now?
Yes, Robert will go ahead and put the break sign up.
All right, everybody be back at 3:12. Thanks. All right. So it is 3:12, and I'm gonna go and get started. Eric, I'm sure will have the PowerPoint back up shortly. I just wanted to let everybody know I did answer a question. There was a question about service plan. Is a service plan required for involuntary inpatient placement petitions? The answer is no. The service plan requirement is only if your petition includes a request for involuntary outpatient. And then, Maria, I thought I had answered your question already about the time limit between the Baker Act as written to the time the patient arrives at the facility. I don't understand your question. I can only tell you that the Baker Act, when it's initiated, is good for 72 hours. If that 72 hours expires before they arrive at a receiving facility, then it is not valid. So in theory, then 72 hours is the time limit. All right.
Melissa, can a proxy or surrogate, can a proxy or surrogate approve administration of IM medications when the patient refuses oral medication? Same for a plenary guardian. Or are they required to be ordered by the court?
If their proxy or surrogate allows them, if it specifically states they can decide on medical treatment and medication, something like that, then no, there's not a separate order required. But that is a legal issue, and that's not addressed in the changes, and this is really about the changes. So whatever you've been doing is probably what you should continue doing. Okay.
Somebody asks, anyone who is qualified to initiate a Baker Act can do so for involuntary outpatient services so long as the service plan is agreed upon between the client and the provider. And if an agreement from the client is required, what makes it involuntary?
It doesn't say agreement. What it says is the service plan has to be developed with the client and or guardian. Let's see, where was that question? Okay, hopefully that answered your question. The other thing that I found out is that an electronic copy of a Baker Act is fine. You don't have to have the original. All right.
And can law enforcement initiate involuntary examination for a minor?
Yes. Okay. So they are allowed to initiate involuntary examination by law. However, their particular agency may encourage them not to do so, or may have a policy in place that says, no, you can't. But the law absolutely allows it. Okay, I think let's see. I don't know why I'm stuck. Huh. Can you forward the
Yes.
PowerPoint? Ah, there we go. All right. With regarding discharge planning, still, inpatient staff must make attempts to engage guardians and significant others in discharge planning. That's important for obvious reasons. They are the most likely to be the person's support network once they are discharged. Discharge instructions must be reviewed with the guardian and or significant others, including prescribed medications, follow-up appointments, and recommended resources. Again, obvious reasons for that. Interim services must be initiated if the recommended level of care is not available at the time of discharge. And if interim services are not available, the receiving facility should contact the managing entity, Medicaid HMO, private insurance provider, or DCF for assistance. For high utilization of crisis services, providers must develop and implement policies and procedures for addressing the needs of high utilizers, including review of effectiveness of previous discharge plans, which we discussed earlier, how the new discharge plan will address the problems experienced with implementation of previous discharge plans, and strategies to reduce the need for future crisis stabilization services. With regard to noncompliance with involuntary outpatient services must be reported to the court. Noncompliance may be determined by a psychiatrist, a clinical psychologist with at least 3 years of clinical experience, or a psychiatric nurse. A person may not be incarcerated for noncompliance with their court-ordered services. A couple of other things, the requirement for a hearing for voluntary admissions of minors is removed throughout the law, which I believe all of our minor providers, or youth providers, I guess I'll say, receiving facilities will be happy with that one. And the limitation of 30 beds for crisis stabilization units is removed. All right, we're going to launch into Marchman changes. And somebody asked, in discharge planning, if someone is identified as a high utilizer and must be referred to care coordination, what if they refuse services? What follow-up needs to be documented? So I would document all of that, but I also would attempt to use the outpatient treatment order. And somebody did ask earlier, what good is outpatient treatment if people can refuse? The only thing that I can tell you is that I personally, depending on the person's presentation and risk, there are times it should be used and times where it's not necessarily going to be effective, but I've seen it be incredibly effective for individuals and prevented them from bouncing in and out of the CSU or a psychiatric hospital. Prevented them actually from having to go into FACT because we did it as an interim service, even though there was a referral to FACT, but the interim service was so effective that they'd never had to go to FACT. So I think it has a time and a place, and you have to decide that as an organization. Legislative changes to the Marchman Act. All right, Chapter 397 addresses the Marchman Act. It is also known as the Hal S. Marchman Alcohol and Other Drug Services Act. The Marchman Act was passed into law in 1993. It provided for voluntary and involuntary services for individuals who are impaired due to substance use, developed a full continuum of licensed substance use prevention, intervention, and treatment services, emphasizes access to the least restrictive and optimal level of care appropriate to the individual in need, protects the rights of persons served, especially for involuntary admissions. So one of the changes is Marchman Act involuntary admission criteria have been amended to state that family members or friends who may help an individual avoid harm must be able and responsible in addition to willing, and that mirrors the Baker Act. Involuntary admission of the person must be to the service component that represents the most appropriate, in addition to the least restrictive. So one of the things that the new Act, HB 7021, did was combine some steps that were historical in the Marchman process. So the Marchman process used to include a petition for assessment and stabilization, followed by a petition for treatment. And now that has been combined into one judicial process for involuntary treatment services. All references to involuntary assessment and stabilization petitions are removed and replaced with involuntary treatment petitions. 5 sections of the Marchman Act that addressed involuntary assessment and stabilization as a separate process have been repealed. In emergency situations, the petition for involuntary treatment can still request an ex parte order for assessment and stabilization. And the court may still use an ex parte order for assessment and stabilization solely based on the content of the petition. And examples of an emergency may include recent overdoses, person found unconscious with a needle in their arm, selling sexual favors for drugs, etc. The involuntary treatment petition, a person may be the subject of a petition for court-ordered involuntary treatment if that person reasonably appears to meet the criteria for involuntary admission, has been placed under protective custody by law enforcement within the previous 10 days, has been subject to an emergency admission through a professional certificate within the previous 10 days, or has been assessed by a qualified professional within 30 days. For those of you who have worked under the Marchman Act at all, know that this is a pretty big change that I believe will make a big difference in our ability to, and family and loved ones' ability to get people into treatment. Regarding court proceedings for the Marchman Act, a hearing is scheduled within 10 court working days of receiving a petition. The petitioned individual must be present at the hearing unless the court finds that A, the individual knowingly, intelligently, and voluntarily waives his or her right to be present, or B, upon receiving proof of service and evaluating the circumstances of the case, that his or her presence is inconsistent with his or her best interest or is likely to be injurious to self or others. The petitioned individual may waive his or her right to an attorney. The court must hear testimony from individuals, such as but not limited to family members familiar with the individual's substance use. Again, similar to the Baker Act, that's important that it says the court must hear testimony. They do not have discretion to refuse. Qualified professionals who executed an involuntary services certificate are no longer obligated to be a witness at the hearing. Witnesses may attend hearings remotely, but they must provide all relevant documents by close of business the day before the hearing. And the clerk of court must provide court orders for involuntary treatment services to DCF and the Florida Mental Health Institute, in addition to the managing entities. So that is all very similar, if not exactly the same as the Baker Act. Regarding court orders, if the individual has not been assessed prior to the petition or through an ex parte order, the court must order an assessment. Once assessment recommendations are completed, individuals recommended for treatment may be ordered for involuntary treatment services for up to 90 days. The court and courts now have explicit authority to order drug tests. Regarding involuntary assessment, a service provider may hold an individual for assessment up to 72 hours. However, the person may be retained longer if the individual is in active withdrawal or is treated for other medical conditions until the medical conditions are resolved, but no longer than the next scheduled court date. The provider may also seek additional time from the court if necessary. If the 72-hour or extended observation period ends on a weekend or holiday, the individual may be held until the next court working day. So all of that mirrors the Baker Act. The requirement that an assessment completed by a qualified professional be reviewed by a physician is removed. Assessments for minors must be initiated within the first 12 hours of admission, also aligning with the Baker Act. Assessment recommendations must be provided to the court before the close of business the day before the hearing. The assessment recommendations must contain a recommendation on the level of substance use treatment, if any, the relevant information on which the findings are based, and any co-occurring mental health or other treatment needs. For extension of treatment, a petition for renewal of the involuntary treatment services order must be filed if the individual continues to meet criteria for individual services. The petition for the renewal of the order must be filed with the court before the expiration of the court-ordered services period. That's the same as the Baker Act. The petition may be filed by the provider or by the person who filed the petition for the initial treatment order. All right, regarding court jurisdiction, the court maintains jurisdiction from assessment through treatment. Specific jurisdiction of the court for individuals under an involuntary treatment order has been added, including monitoring compliance, changing treatment modality, initiating contempt of court proceedings, and setting hearings. If during a Marchman hearing, the court determines the respondent meets any of the Baker Act criteria, not just being likely to injure self or others, the court may order the respondent for an involuntary examination under the Baker Act. Regarding involuntary outpatient services under the Marchman, criteria that must be met before an individual may be ordered to involuntary outpatient services are added, including an assessment by qualified professional recommending outpatient treatment. Services must be available in the county the respondent is located. The respondent is likely to follow an outpatient care plan. The order must include the individual's need for treatment and the appropriateness of less restrictive service options.
Melissa,
Yeah.
can a Marchman Act receiving facility refuse a Marchman Act?
So that answer has always been yes, but I do not know, to be honest. I think that you have to, well, let me back up. My recommendation would be to talk to whoever does your DCF licensing and ask them what the requirements are, and then figure out what your facility's rules are. So by law, yes, you can, but I don't know if it's always a good idea or ever a good idea. I think you all have to figure that out. That's another one of those sort of legal, it's one of those things that falls under the legal disclaimer, in my opinion, because one of the things your organization has to concern themselves with is risk. If you refuse one and that person goes out, something negative happens to that person, then what? And who are they going to blame? So I think that the best thing you can do is take that to your leadership team and get an opinion from risk as well as legal, just to cover yourselves. Okay. Involuntary outpatient services. Individuals ordered for involuntary outpatient must be supported by someone in the community who must report any noncompliance to the court. That can include a social worker, a case manager, or a licensed service provider, a willing, able, and responsible individual appointed by the court. And then the section regarding guardian advocate in the Marchman Act. Let's see, what does it say? Sorry, lost my place there. The section of the Marchman Act on petitioning the court for a guardian advocate for individuals deemed incompetent to consent to treatment is repealed. All right, discharge planning for Marchman. New discharge planning requirements include addressing the patient's needs for 1, follow-up behavioral health appointments, 2, information on how to obtain prescribed medications, 3, information pertaining to available living arrangements and transportation, 4, referral to recovery support opportunities, including but not limited to connection to a peer specialist. Other Marchman Act changes include having a substance use disorder and use of illicit or prescription drugs is added to the definition of impaired or substance abuse impaired. And I will tell you that the reason I think this is important, and I'm hoping that all the receiving facilities out there agree, is that prior it just said impaired, and that was interpreted as someone who is actively intoxicated. And so I, for one, am glad that they have now clarified that to having a substance use disorder and use of illicit or prescription drugs. The second, providers operating addiction receiving facilities or detoxification units may exceed their license capacity by 10% for no longer than 3 consecutive days and no more than 7 days per month. And that aligns, for those of you who have both a CSU or a Baker Egg receiving facility, specifically a CSU, and an addiction receiving facility, you know that aligns. That's exactly what the statute says about CSUs. All right, so additional changes. These are some good things. Regarding background screening, the new legislation actually reduces background screening requirements. And why that's important is physicians and nurses holding an active, unencumbered Florida license are no longer subject to background screening requirements. The reason is because Florida recognizes that these professionals are screened as part of their initial and ongoing licensure process. So if you're not aware, right now, as providers, we have to do new background checks every 5 years on people. And this, I mean, we had to, so if you think about it, nurses and physicians who had an active license had background checks done on them every 2 years or whenever their license was up to be renewed, and every 5 years based on their employment with us. So this removes that 5-year requirement in recognition of the fact that they've already got background screens done. Additionally, I see this as helping with when they first start with your organization, because if they have an active unencumbered Florida license, you shouldn't have to then wait for the background screening results to come back. You can assume that they're cleared and start them right away, which has been burdensome for all of us, having to wait for those background screenings at times. Regarding the ombudsman for children, so the new laws create an Office of Children's Behavioral Health Ombudsman under DCF. And the purpose and duties include to be a central point to receive complaints regarding state-funded services for children and direct them to the responsible entities, to provide education to families on the behavioral health system of care, analyze complaints and make recommendations to address systemic issues, and engage in functions that may improve services for children. I think we can all agree that those are all really good, noble activities. And so I am, for one, excited about the creation of this particular office. Regarding transparency, the law also states DCF and the Agency for Healthcare Administration must provide data to the Florida Mental Health Institute related to involuntary examinations, and the Florida Mental Health Institute must analyze service data for high utilizers of crisis services, identify any patterns or trends, and make recommendations to decrease avoidable admission. Behavioral health interagency collaboration. So DCF and ACA must establish behavioral health interagency collaboratives throughout the state. The goals are to 1, identify ongoing challenges at the local level, 2, facilitate enhanced interagency communication and collaboration, and 3, develop strategies to address changes and improve access, availability, and quality of behavioral health services. Members include, but are not limited to, state agencies, including APD, the Department of Education, the Department of Health, etc., funders, the managing entities, the CDCs, the HMOs, etc., law enforcement, school district, and service providers. I personally think collaboration is always good, so I'm happy to see that there. And then regarding funding, House Bill 7021 included a recurring allocation of $50 million to enhance discharge planning and increase capacity of acute care settings. This is really important. One of the things that was recognized by everyone is that the enhanced discharge planning does require resources. And so that is why the 50 million was included. And then Senate Bill 7016 includes a recurring allocation of 11.5 million to enhance crisis diversion through mobile response teams. And we talked about that early on, I think in one of the first couple of slides. Mobile response teams have been incredibly effective, and obviously we hope they will continue to be so. And so the legislature and the state agencies are interested in increasing the scope and increasing the resources of the mobile response teams. All right, so you're probably wondering, what do we do now? So you want to make sure, obviously, that you go through the law. I do believe this PowerPoint will be provided or accessible, which will help you when you go through it. So you're going to want to review and update your policies, train your staff on the changes, and then obviously implement the changes. And they did take effect July 1st. So it's important to note that the faster you do this, the better, to make sure that you're in compliance with the laws. All right. At one point I was worried we wouldn't get through it, but we did. So, Robert, I am ready for questions, the ones you've been holding.
Sure. Somebody asked a little while ago, can you define the term initiation?
So initiate is, if you think about it in very concrete terms, you have a form that says involuntary Baker Act, or something like that, and you fill that form out and you sign it, you have then initiated an involuntary Baker Act. Same thing with Marchman.
Got it. Somebody asked, when a Baker Act expires on a Saturday or Sunday or a holiday, that client is not agreeable to sign voluntarily for a longer length of stay. Would that client need to be discharged, or is it okay to wait until the next business day?
No, you wait till the next business day. And I think that was in one of the early slides. I can try to go back to it. You just have to make sure that you really actually do it the next business day, because it also specifically states the court will dismiss any petition that's filed late. See.
Understood. Do Marchman court recommendations need to be signed by a psychiatrist or physician?
Gosh, I'm trying to remember what I said about that. What was on the, let's see, my lifeline is texting me. No, they do not need to be signed by a physician.
When will these changes be reflected in the Baker Act / Marchman Act handbook? And when will the recommended forms be updated?
So I'm not sure I can ask that or answer that, rather. I don't know, because that's up to, I believe, the Department of Children and Families. And one thing, just back to the other question, the Marchman recommendations have to be by an assessment by a qualified professional. So whoever the qualified professional is, it does not have to be a physician only. As far as the handbook and the form, DCF is in the middle of working on that. Same thing with the Ombudsman office, because one of my questions was, well, when will that be created? They are working on that. They've interviewed some folks and are hoping to get that office up and running as soon as possible.
Does a person's legal status interfere with Baker acting that person?
Are you talking about legal status as in, do they have a guardian? Have they been determined by the courts to be incompetent? Whoever asked
I'll
that
let
question.
that person clarify.
So I will say this: a person who's been declared incompetent by the courts and assigned a guardian by the courts cannot be voluntary. So a Baker Act has to be involuntary. That's the only way I know how to answer that question.
Somebody said they were under the impression that physicians did not do a background screening when renewing their license, just an attestation as they do for their LMFT license. Is that not correct?
Well, let's see if my lifeline has an answer. Hopefully she'll text me. I can only tell you what I've been told when preparing for this presentation, and that was that they don't have to get we as providers don't have to get the background screening done for physicians and nurses because it is done when they apply and renew. And personally, I was not familiar with that as an LMHC. That doesn't happen for me to get licensed, so I don't have the experience to answer that question, I guess.
Are APRNs able to give orders for ETOs?
Yes, that was in one of the earlier slides.
Can a family member initiate a request for a Marchman Act by calling 911 if they believe the person is a danger to themselves or others? What would take place thereafter?
They can, but law enforcement may not initiate it. A better bet is to go to the courthouse and file an ex parte to petition the courts. And what would happen thereafter, that particular option, is if the judge grants it, then a pickup order would be issued for the person, and they would, law enforcement would be tasked with going out to look for the person, and then that person would be brought to the receiving facility. Same thing happens with Baker Act.
I have clarification on whether a person's legal status can interfere with their ability to be Baker Acted. That person responded if they are undocumented.
No, that has nothing to do with the Baker Act or Marchman Act laws.
And then it looks like the last question I have here is if a licensed professional is not available, can a law enforcement person refuse to Baker Act?
Oh yeah, anyone can refuse to Baker Act, including a licensed professional, because it's a professional personal decision. Whether you're law enforcement or an LMFT or an LCSW or a psychiatrist or a psychologist, no one can force you to initiate a Baker Act.
I think that's all the questions we have for the moment. Let's see. Oh,
In reference to the background checks, we'll get clarification as to why that was removed, because everyone's saying that the background checks aren't done. And perhaps it only applies to initial licensure. I'm not sure, but I'll try to get clarification on why that was changed. But the big thing for providers to know is that you don't have to do the background screening.
somebody said they have PMHNPs with less than 1 year of experience that are telling us they cannot write a Baker Act because of the 394 definition for a psychiatric mental health nurse.
Yeah, I don't know. So in the past, there were limitations on their scope. And again, this is probably one of those that will fall under a legal requirement. I know that the Nurse Practitioner Association puts out information to all the nurse practitioners. And what I would do is get their information and see, because, it's entirely possible that the information under the licensure for the NPs is in conflict or not as explicit, maybe not even in conflict, but not as explicit perhaps as the Baker Act law and Marchman Act laws. What you have to remember is that this is a different section of the statutes. And so I think the best thing you can do is pull down both the licensure requirements and the Baker Act and Marchman Act law and compare the two. And if you find something that seems contradictory or isn't clarified in one or the other, if you let us know at FATR or FBHA, it's something that we can look into and potentially ask to have clarified in the future.
Got it. Does a 72-hour start time for Baker Acts received at a facility apply for the Marchman Act as well? There is no start or stop time at the hospital now for Marchman Act.
Yeah, I think that, let me go back to Marchman, because I think that it specifically addressed the 72 hours. I don't want to speak incorrectly about it. So this is the one that addresses that a service provider may hold an individual for assessment up to 72 hours. And the same thing as with the Baker Act, if the 72-hour or extended observation period ends on a weekend or holiday, the individual may be held until the next court working day. And what you have to do with the next court working day is file a petition.
I think that answers the next question. What needs to be filed in order to hold a client longer than the 72 hours for an evaluation in a Marchman Act?
That is the petition for treatment, which is back here, involuntary treatment petition.
Somebody asked for clarification on qualified professionals not being required as a witness in court proceedings. Does that include depositions?
Depositions are different. So the presentation is specifically regarding Baker Act court, which is civil court. Specific to Baker Act and Marchman Act procedures, so I can't answer that question regarding depositions. If someone's taking depositions, I mean, typically if you're doing depositions because you've specifically been subpoenaed to do so.
How do individuals receive notification of the new handbook and forms once they're made available?
If your organization is a member of FBHA, that information will go out to all members.
Somebody asked, what is the best email to send questions? Diane, we'll get to that in just a moment. How is the petition for involuntary outpatient services initiated? There's no option for that on the current Baker Act form.
No, but there is a current form that pertains specifically to it. So the best I can say until we have a new form is to use that.
Where can that form be found? Is it on the DCF website?
Yes, it should be. If not, that's another question that can go to FBHA, but I believe all the forms are on the DCF website. At least that's the last place I pulled down a Baker Act form.
An individual asked, ex parte orders used to allow 5 days for the Marchman Act evaluation. Is it now only 72 hours?
That is what it says. Yes. Let's see, where did that go? I had that up. Well, where the heck? There it is. All right. Anything else?
Is an MCAP or CAP a qualified professional?
That is a good question. I will, let me check with my lifeline here. Yes, for a Marchman.
And this question, I believe, has been answered. If the 72 hours is not long enough for the ex parte, what form needs to be filed to keep the client longer? And that is the petition for treatment, correct?
Correct.
And somebody copied the link to the DCF website for Marchman Act and Baker Act forms. Thank you. I believe that's all the questions we have for now.
All right. Well, again, thank you all for joining today. I hope you found this helpful. It is always an imperfect science trying to interpret changes to the laws. But I believe, as always, we'll figure it out, and we'll provide information regarding questions I was not able to answer so that you all will have it. And of course, the PowerPoint will be available. And I'm sure DCF, it's a lot of work to change those handbooks and forms, and I'm sure that they'll have that done soon. And I'm glad all of you are safe from Helene, and wish you a wonderful week.
Thank you so much, Melissa. Everybody, please hang on for just a moment for some conclusion items before we wrap up the webinar. First thing I want to address is I know that this was a topic where we had many questions, and we will do our best to get those addressed after this webinar. So give us a few days for us to pull all of those questions, make sure that we answered the ones and get the ones that we didn't answer figured out and get those questions answered for you. So please hang on for that. You can also email Melissa. Her contact information is on the screen. melissa.larkin-skinner@caslink.org. So you can email her with any questions. Before we conclude today, I'm going to post a link to the evaluation in the chat. Please make sure to get that completed. Melissa, thank you for all the information you shared with us today. I know this was very helpful. This was a very highly attended webinar, and there's a lot of engagement in the chat. So we appreciate you sharing the information about the updates as well as answering the questions. The evaluation link is in the chat. Additionally, when I end the webinar momentarily, your web browser will populate a message that looks like this on the screen. It says the host or presenter would like WebEx meetings to open a website on your computer. That is not spam. That is WebEx trying to redirect you to the evaluation automatically. So click continue to be redirected to that evaluation. To complete that evaluation, you must sign into your FATA account. If you have not created an account as of yet, you can register at no cost. You may do so by clicking haven't registered yet. Please use the same email address you used when you registered for today's webinar when you set up your profile in FATA system. That's the only way for us to connect your attendance to your profile to ensure you get your statement of completion. For CEUs to be reported to CE Broker for Florida licensed healthcare practitioners, you must provide an accurate Florida Department of Health license prefix and number the first time you register. If you need to add or update your license number, you may do so by logging in and clicking edit on the professional information section of your profile. You will get an additional opportunity to complete the evaluation through a follow-up email later today. As a reminder, the evaluation will close on the end of the day on Thursday, October 3rd, 2024. For assistance with account login, registration, or evaluation completion, fill out a Contact Us form on our website. Please note that we do not email statements of credit. Instead, after we verify attendance and completion of the evaluation, a statement of credit will be posted to the professional development section of your profile on your FATA account within 30 business days. You must have attended the entire webinar and completed the evaluation for a statement of credit to be generated on your FATA profile. As a reminder, the recording and materials used in today's presentation will be available on the FATA website and our learning management system within 30 business days. To access the recording in PowerPoint, visit www.fata.org, navigate to the Resource Center, and click on Training Library as shown on your screen. Thank you everyone for participating in today's webinar. We'd also like to recognize and thank the Florida Department of Children and Families for funding today's education. Have a great day everyone, and please hold for the